Good evening, everyone. My name is KENNETH VERCAMMEN. It's time to start and teach people a little bit about wills, estates, and things like that. So, if we're on the topic of what we're talking on, if you have a quick, easy question that deals with New Jersey, then I'll try to stop and answer it. And then after I go for my 40 minutes, then 39, then my colleague Dan Fabrizio is going to talk a little bit about financial advisor and answer someone else's question. But a lot of times when people say, Kenny, why do I need to have a will? Doesn't it all go to my spouse and my kids? He goes, well, yes and no. Depends if there's children from a different relationship, or sometimes you don't want people to get it. But that's not doing planning. It's like not having life insurance because you're never going to die, or you don't need it. Of course you need it. So by doing planning, it helps your family. And part of the goal is to have people less aggravated down the road and to save them some money. So, because if someone doesn't have a will, or like the surrogate says, they tried to do it themselves and they screwed it up, which is what they see a lot of the problems, then there's no, if it's not signed right or done right, then there's no will, and then they have to go through this more complicated procedure called an administration. When there's a properly done will, it's called probate. The administration process means all the kids got to agree upon who's the administrator. The people who aren't going to be the administrator got to sign a renunciation in front of the notary and pay a fee to have that filed. However, sometimes you got one of the kids who says, no, I'm not going to do it. I want to be the administrator. So then they got to spend like $3-4 grand, file a complaint order, show cause in Superior Court, and have the judge appoint the person who wants to do it as the administrator. Sometimes the judge will say, I'm going to appoint someone on the outside that'll charge you even more money. So the whole idea is when the family's grieving, they should have one more thing. But part of the thing is get the stuff done now. Don't wait. Once a week we get a call. Oh, I need to get power of attorney over mom, dad, my brother. Oh, you can't get power of attorney over anyone. They have to formally do it for you. And if someone's already in the hospital or sick, can't sign, it is too late. So think about it. Who you want to get your assets? Think about who you don't want to get your assets. Because remember, it's your right to do with your assets what you want. More and more people aren't giving their money to their kids. Their kids are already grown, or like they're leaving it for their grandkids so it can be used for college, maintenance, things like that. Sometimes someone says, listen, I love my spouse, but my spouse is like about to go into a care facility, and I'd rather have more stuff going to my kids than my spouse in the event. So think about, remember, it's your right to do. The only thing you can't do is disown a spouse, but who do you want to get your stuff? And sometimes, who don't you want to get your stuff? I'd say, when people have minor kids, I'd say, listen, you don't have much assets, but you have your minor kid. Do you want to put down now who's going to be the guardian, or do you want a bald white guy in New Brunswick to decide? Because that was who the probate judge was at the time. Doing a will is actually a lot easier in a way since COVID. Before COVID, the old system was you call the law office, you make an appointment, you come in, then you be in the reception area writing stuff down, and then half the time sometimes we couldn't understand people's handwriting. Now we email out an easy questionnaire for most of the seniors or people who got minor kids. What's your name? What's your address? Who's Executor 1? Who's Executor 2? Who gets your stuff? Not that complicated. Not that complicated at all. And also, like after my wife retired, she goes, I want to be in charge of collecting the money. So she's better at that than me because I got enough stuff to do. So, okay, what do you need? What does the attorney need? Like I said, your legal name, what your address is, and if you have a legal spouse. I started saying that because a lot of people sometimes they refer to it as my spouse, and but they're not legally married. One time we even did a will for husband and wife that I went to college, University of Scranton with their daughter. After we signed, the husband goes, does it matter that we're not really married? I go, well, of course, what do you mean you're not married? He goes, well, because about 11 years ago we got divorced. But we never, we worked it out. We've been together, I goes, yeah, it does matter because it says my wife. Another time after we signed it, the guy goes, does it matter that that's not my legal name? Okay, of course it matters. He goes, and this is a guy I knew from the Edison Elks. It wasn't a stranger. I go, what's your legal name? He goes, my legal name is Elmer, but I've been known as Buddy since I was in, grammar school because Bugs Bunny, it was Elmer Fudd, and everyone would ask me hey, how's that rascally wabbit? So I goes, yeah, it does matter because that's not your name. Okay, so the whole thing is, and some people goes, oh, I'm not that good with the email, etc. I goes, listen, you have a child or a grandkid that is probably better than you. One lady, she joked, her granddaughter lived 2 towns over. She tells the granddaughter, listen, I need you to come over the next 2 weeks and help me with something on my computer. She goes to the granddaughter, I'm going to give you $5,000 if you do that. Okay, of course we said, if the granddaughter says, I'm too busy, grandma, to come over and help you for 30 minutes, okay, no problem. I'm not going to leave you anything. She wasn't asking her, to come over and cut the grass or shovel snow in the winter. Now, you want to have an executor number 1 and executor number 2. The executor is the person who, carries out the terms of the will and distributes the assets. Some people says, well, I got 2 kids, I want to, I don't want to pick one over the other. He goes, listen, if you make them joint, they got to do everything together. You're making more work, not less work. They could be identical twins living in the same house, but that means 2 people got to sign every check, 2 people got to do everything. I go, if you don't want to decide, I'm going to help you. We're gonna flip a coin. One time, a different person at the Elks Club, he goes, I feel bad picking one daughter over the other. He goes, hold on. We're writing down the names on these pieces of paper. We shuffle them around. Oh, the other guy goes, hey, stranger, hey, pick one of those papers. Okay, Audrey's going to be executor number 2. That was that scientific. Because being the executor is not that complicated when there's a will. Believe it or not, New Jersey's the probate easy estate. New Jersey has reduced taxes. The only thing they reduced taxes on. 10 years ago, every penny over $600,000, it was a huge tax. Now, I'd say New Jersey did away with the estate tax. There's no inheritance tax if it's going to spouse, children, grandchildren, but there is a federal estate tax. But that's only for the people in this room that have more than $15 million stashed away. I don't know anyone in all of Piscataway that has $15 million stashed. And certainly they don't want people to know that, because they won't bother, because people will bother for money. Okay, so, let's see. Now, and we no longer, because there's no longer an estate tax, I don't need to know a lot of details on assets. The question is, what real estate you own here, what real estate you own anywhere else, and is everything else more or less than 15 million? Sometimes people goes, oh, I haven't got around to doing it because I'm getting you the account numbers, and I goes, oh, I don't want your account numbers. I just need to know the whole amount. It's different when it's a probate matter where you got to put account numbers on the inheritance tax return, but just really what real estate you have, what's the total amount. Then it's simple enough. Who's going to be your beneficiaries? Let's say, and you also put down if one of those beneficiaries passes away, who gets their share. Don't let anything go to a mystery. And it can't be like someone says, well, I'm going to have everything go to my oldest daughter, and then she's going to distribute it. I goes, well, I can't do a legal will that way. She can be the executor number 2, but because here's the other thing. I'm sure you trust that daughter, you love that daughter, you know she's going to do the right thing while you're alive, but if she if she passed away, who gets all those assets? Whoever they're married to, or that person's kids. And I'll touch upon that down a little bit later when we deal with the Medicaid portion. So, that's why assets are not listed in the will. However, there are certain assets that go directly to wherever you have the beneficiary. A will can't change that. So, for example, if a house is owned husband and wife, and one of them passes, the deed says it automatically goes to the surviving spouse. The will can't change that. Okay? If you have an IRA, 401k, there's beneficiaries, life insurance. The will can't change that. So I also recommend that after people have a printout of the page of if you have assets that have direct beneficiaries, print out that page, and then you can just keep it where you have your will and other documents to help out your executor. And helped out a family. I was on TV last month, the News 12, New Jersey. This man dies. The kids had the printout of his life insurance that said that they're the beneficiaries. Well, this guy had gotten remarried late in life, second wife, and she went to the company and said, "Okay, I'm the wife. Give me the money, right?" Well, she wasn't the beneficiary. But the life insurance company says, "Okay, fill the form, we'll pay you the money." Then the life insurance company was trying to backtrack and say, well, we already paid out the money. So at least News 12 and Walt King got involved, and they had me, also talking about it. He goes, "Hey, that's the insurance company's problem. If it's supposed to go to someone, then the insurance company, they got to pay. That's the law." So it's, on the other hand, another lady that didn't have a printout, and she goes, "I saw my father put me down on his annuities. I saw him do it. He signed it, put it in the mail." I goes, "Well, the company don't have it. You don't have a copy. You got a loser." "Well, don't you think they're negotiating?" "No, because you got no leg to stand on." And it goes, "It's just you saying your good word, saying I saw him do something. That's not a win." Now, your will takes care of your assets. Some people have what's called specific bequests. What a specific bequest is where some people say, "Hey, listen, I want to leave each of my grandkids 10 grand, or a certain amount." Some people say, "I want to leave, 10 grand to my church, my school, whatever charity you're involved." Now, I fully support taking care of charities, okay? But I do tell people, I goes, if you do leave money to a charity, and it is a percentage, that's going to prevent everyone from getting their money for at least a year. Because whenever charity's getting, anything more than $500, first we got to notify the Attorney General. And let's say the charity's getting, 5 grand. Well, if they're getting a set amount, charity gets the money, then we got to submit proof to the Attorney General. But if that charity's getting 1%, then the Attorney General's office gets more involved, and then they say, we want a formal accounting, and no one gets their money until they approve it. And one mistake, it costs almost 10 grand for the formal accounting by the accountant. That was more than what the charity was getting. So again, I support charities. And I also said, you want to always have clauses. If a beneficiary guesses who gets that share, don't have it just as a mystery, because the executor can't just say, "Well, this is what I'm going to do." All right. Now we talked about the specific bequests. Okay? Now there's also something that we refer to as the reverse specific bequest, and that is, I leave nothing to X. We're not leaving him $1. We're not leaving him a reason. nothing to that person, but it got to be in the four corners of the will. And also, it has to be, everything got to be in writing. Right? You know, at Christmas time, you know, Mom could have said to everyone in the room, and someone's videotaping it, hey, listen, and Merry Christmas, everyone. I want you to make sure that when I pass, all my jewelry goes to my granddaughter over there. Okay? And if people, oh, Grandma, don't talk about that. Well, not when she passes, not only does the executor not have to follow what Grandma said in front of everyone that's videotaped, not really allowed to, because it got to be within the four corners of the will, or everyone got to agree in writing. And you don't want to rely upon everyone having to agree in writing, because sometimes, a lot of times the person that clogs up the works isn't your blood relative. It's whoever they're married to. You know, we were involved with litigation one time, and Mr. G keeps on calling our office, when are we getting when are we getting our money? And finally I say, by the way, Mr. G, you're not getting any money. That's all going to your wife. And, you know, like, I want to say, you're lucky we've been talking to you, because you're the one that's causing all the problems in the family, not the blood relatives. So, bottom line, nothing to. We also want to have a clause that says 18-year-olds don't get anything. They either get it when they're 21 or 25, something like that. Let's say, who in this big room would have did wise things with money when you're 18, 19 years old? Geez, I would have bought a red fast car, and I would have had that place down at Seaside for the whole summer, and I wouldn't have worked, you know, 40, 50 hours a week, you know. And I went to high school with the guy that his mom had passed, and his father at Sunday was killed. All of a sudden, he's getting $75,000 in 1978 money, and that kid didn't have 2 cents when he turned 21, because he went on parties and drugs and you know, going out wild. So you got to protect. You know, I'm talking to a man last week, and he goes, "Oh, no, I don't need that." He goes, "Sir, listen." He goes, my son is very responsible." He goes, "I'm sure your son is responsible. He's 17 years old, and he respects you, and he could be the valedictorian of the school. But if the two of you weren't there, he's going to get everyone in the whole high school is going to know that this guy's getting $400,000 or whatever, and he's going to have new friends. If it's a guy, it's going to be a girl. Oh, you know, how come you haven't bought me any nice jewelry recently? You know, and then all the dudes are going to be, hey, you don't need to work this summer. This is your only opportunity for us to get that shore house. Oh, and this is your only opportunity to go to Maloof and buy a $200,000 car. You don't need to go to college. You got $400,000. College is stupid. Anyway, so you got to protect them from like the people that I met. I also mentioned for the people that have minor children, they should set forth who would be the guardian for the kids. See, the surrogate's office, when we've done lectures with it, always says, listen, have it done right and have what's called a self-proving will. There was a change in the law. In the old days, the person signed in front of 2 witnesses. But then one of the 2 witnesses had to go to the circuit's office or sign an affidavit saying they were the witness. And sometimes they can't find that person, I'd say. Or, you know, they died, whatever. I remember when my grandma passed, we found one of the witnesses, because it was done the old way, and the lady goes, oh, lady, my fee to sign the form is $500. Father goes, I'm paying you $500. Lady goes, yeah, okay, get the other witness. Well, she's dead. Yeah, my fee is $500. Well, we could have said, you know, forget you, lady, but it would have cost us thousands of dollars more. So, the new statute, self-proving will, the person signs, then there's 2 witnesses, then the attorney and notary. Then there's another page, everyone's just signing twice, and it has to have a specific New Jersey lingo.
Question.
Yes, ma'am.
The witnesses, can they be co-workers of the lawyer?
The witnesses can be anyone who's over the age of 18 who is not insane and can sign and see. And in a way, sometimes like, when we've done lectures to the other attorneys, they're kind of better because sometimes there's allegations of undue influence or shenanigans. When they see these wills that are prepared by somebody, and then they're signed, while they're in the hospital, that all of a sudden it's a new will and someone is coming in. And who's their witness? Oh, their friend. And so sometimes, and I've refused to handle cases where I said it smells. If food doesn't smell good or taste good, it doesn't get better by time or putting it in the freezer. See, my mom used to take bread that was kind of moldy and put it in the freezer. Well, she was a Depression era lady. But we always, whenever we go to their Poconos house, my wife and I, we'd be just taking all this freezer burned stuff and we're gonna throw it out before your mom gets in. Because it's no this stuff's no good. The witness now, the person who should not be the witness, if possible, is family members that stand to get more than someone else. Legally, a spouse can be a witness, but it's better to get someone else. That's why my office signs documents between 10 o'clock and 3 o'clock when we have live human beings in the office that don't know anyone. And we got a checklist, and they ask all the questions. Okay, did you read the printed version? Not did you read it on your phone? Is the people's names spelled right? Is it correct? And do you have ID with you? If someone says, no, I didn't read it, but my daughter says it's what we want. Have a good day. You're coming back another day. I remember one time, really said to my office, no, I didn't read it, but my daughter says it was okay. Well, okay, you're coming back another day. Then the daughter says, oh, she misunderstood. She did read it. I goes, no, man, listen, we heard what we heard, and I'm not jeopardizing my license, on the fact that now you're saying, because she eyeballed us and said she. And we also want to see, some ID. Also, sometimes you don't leave money to people in your family, not because you don't like them, but because they would not be able to enjoy or use the money as well. So the people that have special needs kids know, hey, listen, I got to set up early on so that they don't get the money and lose their entitlements. Sometimes, though, it's an older kid, but they have money problems, they're in bankruptcy. We were involved with an estate litigation where mom had 4 kids, but one of the kids was an alcoholic, and instead of giving his share, his 25%, she goes, it's going to be held in what's called an inter-virus trust within the will, and the money's going to be held by one of the daughters under his testamentary trust, just with the broker and under his social security number. But she has the sole discretion. So then his ex-wife brings files a motion saying, Judge, I want you to compel the trustee to pay the alimony I'm owed. And I'm representing the estate. I goes, we don't have to pay anything. That's what the discretionary trust is. And I goes, here's the case law. It's even protected from taxes and Medicaid. The judge goes, it says that. Just because someone's first name is Judge, don't assume that they know the law, because some judges may have been a family lawyer their whole career, and all of a sudden they're put in the civil and criminal division. Someone could have been a prosecutor for 30 years, and all of a sudden they're put in the civil division doing car accident cases. It's funny, sometimes some of the people that he made a judge will call me up and goes, Kenny, don't tell anyone I called you out, but I got a couple questions on this. And I go, listen, it stays within the law. Anyway, so in this probate case, the judge says, hey, hey, you're right. That's what people sometimes do. Sometimes people have now, sometimes we've done documents where two people are married, but one person is ill, and it goes, listen, I go, I'd say, you're in good health, but we can't guarantee that you're going to outlive your wife. Let's say she's in a nursing home. We are able to take the house, not have to take her name off the deed, do a new deed, take her name off the accounts, and that way it's protected down the road. You hate to predict stuff or be right, but a year later Louis died, so his family at least was able to get something. Otherwise, it wouldn't have gotten any. So, God, if you don't have a will, get one done. Don't put it off. Don't be like this guy, Louis. Not Louis. Carl. Answer. Carl. So, this guy, Carl, was one of those retired engineers that always when he got a new car, he wanted to take out the book and read the whole book. He got a new car, I want to read how you change the tire, even though you tripped away. So, I tell Carl, listen, we got to do this, this, and this. He goes, well, I want to read up on it. Carl, you don't need to read anything. Listen, I went to law school, I passed the bar, I go to lectures, I wrote a book on this. Okay, you don't need to read anything. And I goes, listen, when I had knee surgery, I didn't read up on how doctors could do it. I didn't want to know. It grossed me out. Every once in a while you see like somebody's videos and goes, ew. Carl goes, I want, he's an engineer. I want to read up on it. Okay, fine. 2 years later, daughter calls us. Hey, do we have Carl's will? No, you want to read it. He died. No, because he wanted to read up on it. He's still reading. But some people who work for big companies have what's called legal plans, MetLife, ARAG, legalese, and that covers the cost of an attorney doing it. Don't put also. Sometimes we got people who say, oh, Kenny, when's your next seminar? I want to go. I goes, I'm not telling you. Just get your will done. No. Get it done. I mean, I do. If someone does comes to our seminar, we do a free consult, but they got to at least provide us with some information, not just drive over the office and want to hang out. Now, the good thing also, a will that's properly done is good now. It's good 20 years from now. It's good 30 years from now. It's good if you move to another state. Okay. Sometimes there may be other things you do in other states, but that might be better for that state. So that's a little bit about wills. Let's see. My mother was 94 years old, and that lady used to call me every other year for 20 years. I want to come in and get a trust done. I want to come in and get a trust. And I would say, were you watching Susie Orman on TV? Oh, and she would say, yes, well, Susie Orman is exactly right. If you live in New York, California, Florida, where the probate process is very complicated. Costs a minimum of 15 grand, takes 3 years. New Jersey probate, the fee is about $190, and the surrogate needs the original will, death certificate check for about $190. We typically help people by filling out the forms online, and then it's done. Let's see. A revocable trust, again, if you have properties in these other states, we recommend that people have these fancy revocable trusts. But most people in New Jersey don't need to spend between 5 and 10 grand setting up fancy trusts. And I'm being honest with people. Listen, I kind of wish everyone would come in and goes, I want to have that, spend $8,000 on doing a trust today. But I also want to be honest with people. I feel bad by trying to sell my next door neighbor or my best man's Mom, oh yeah, you need this revocable. Because most people don't. New Jersey's pretty easy. Okay, so, the only thing a revocable trust does is, it skips the New Jersey probate process, which I said costs about $190. But it doesn't save taxes. A revocable trust doesn't protect any assets from Medicaid or nursing home, etc. They're usually sold by trust salesmen that give you a nice fancy book. You know, oh yeah, avoid probate's the devil. Now, having said all that, if someone says, hey, I still want to get the trust, then I'll do it. But again, I'd rather be honest with people in what I do. You know, when the teachers were smacking us around in grammar school, trying to knock some sense into us, at least that's one of the things that they try to do about being honest with people. Now, there is another kind of trust that some people do, and that's called an irrevocable trust in the event that you have to go into a nursing home, Medicaid, etc. Okay? And hey, Medicaid is $15 grand a month, and it's a 5-year look back. And people, sometimes they go, I want to protect my assets. People, a lot of times it's not the people that want to protect their assets. It's the kids that want to protect their inheritance. This lady brings her mom. Oh, mom wants to protect her inheritance, and I could tell she wanted to protect her inheritance. Not mom. Mom didn't really have any. I go, oh, that's pretty easy. You could take a long-term care insurance for your mom. Oh, I don't spend my money. But then, so what an irrevocable trust does is you're transferring all the assets out of your name, and it's to be owned by the so-and-so irrevocable trust. You're transferring the house, any real estate, most of the accounts, except for certain accounts, like the IRA, certain thing, can't go in because otherwise in the distributions you got to start right away. But I'd say, and then 5 years got to go by, and the only, or someone can say, well, I don't want to spend the 15 grand for this fancy trust. What else can I do? He goes, well, you can transfer all your assets to these kids right away, and hope 5 years go by, you don't have to go into nursing home. But you don't own it anymore. It's a gift. We got to fill out a gift tax return, but but I also tell people, listen, before you run out and do that, because it sounds kind of simple and quick. Okay, Mr. M did that. Mr. M goes, okay, I'm gonna beat the system in case I gotta go into nursing home. So he transfers half his assets to his son, half his assets to his daughter, and then he has the attorney do a quick claim deed. Half of the house is owned by my son, half the house is owned by my daughter. Okay, I just got to live 5 more years and everything's gold. Then the son dies. Okay, now who owns 50% of everything he ever worked for his whole life? He's an ex-daughter-in-law. I mean, daughter-in-law, but the family sends her, a couple letters. Hey, can you do us a favor and give us back all the money and sign a deed? And daughter-in-law's my client. And she goes, what am I required to do under law? He goes, tell me to go screw it. I mean, that was a gift. And your husband passed, and that you're going to have your kids, your daughter get that money. You're not going to go and get a new husband now or go to Atlantic City and go wild. Now we worked it out. We gave some money, to help care for the guy. But now, talking about the trusting. So, one time, the person goes, Mr. Vercammene. And I go, whenever someone says Mr. Vercammene, I look for my dad because he's 93 and he's still alive. My dad's there. Mr. What did you do? And I go, I can get it from free. I go, I'm not transferring my assets into any kind of trust, so I don't have control anymore, and I'm at the whim of someone else. I'm at the whim of, sometimes it's, your kids are good, but whoever they're married to. Okay, so, I'm at the whim of, let's say, a son-in-law or a daughter-in-law, and they're gonna say, oh, they'll get the same care if they go into this facility than the other one. Goes, no, that's not how it works. I said, listen, me, I want to go into the most expensive nursing home that exists. I want my own room where to put a piece of chocolate on, a pillow like it that'll walk off Astoria, because I worked hard my whole life for money. I've been working since I was 13 years old. I'd say, do you know that white stuff that was coming out of the sky for the past couple weeks? I remember bicycling through it with my newspapers in the front. And especially around Christmas, the newspapers are so heavy that I'm falling over because they're this thick. And I'm collecting like quarters and nickels. And then I'm cutting grass, and I'm always working hard. I'm proud that I scrubbed those toilet bowls and dumpsters and picked up garbage, because I worked hard for money. So that's why I get to go into a nice nursing home and not rely upon someone else to say, well, maybe we could save money by sending Grandpa Ken to the one in Alabama. Nah, I don't want to go to one Alabama. So that's a little bit about it. So we covered wills, we covered revocable trust, irrevocable trust. Two other documents that we got to talk about. Next is the power of attorney. Your will takes care of your assets if you pass away, and you're picking someone to be executive one, another person executive two. What the power of attorney is while you're alive, you're having someone, it can be a spouse, a kid, or someone you trust, to say, listen, I want to give you the power so that you can help me out financially if I can't drive to the bank or do something. Okay? The power of, and power of attorney is either effective right away or only upon disability. And it's an important document because, hey, listen, if us married people had passed away suddenly, the law already decides where the assets go and the order of who would be the administrator. But if I slip down the ice at a building not as well maintained as here outside, and I clunked my head, and I'm in a hospital with like a brain clump, and I can't do anything, nobody, without a power of attorney, nobody can do anything legally for me. A spouse has no legal rights to sign for someone else. A kid doesn't have any legal rights to sign unless they went and had a properly done power of attorney. See? In the power of attorney, you have an agent one and an agent two. And it's something that really almost everyone should have. Sometimes when people don't have money, that's more important because at least it's someone to talk on their behalf.
Question.
Yes, ma'am.
Can the attorney be the notary?
The attorney can be the notary. So in my office, it varies. If I'm in the office, sometimes I'm the notary, and it's not really called the attorney as the notary. An attorney and the judge and the Secretary of State are authorized by statute to take an oath of someone. So the notary is really taking an oath and watching his son.
And they don't have to stamp it. All they have to do is sign it.
The attorneys don't have a fancy stamp like the notary because it's easy to find out if someone's licensed or not. Now, having said that, I went out and bought a stamper because people were always expecting when we didn't used to have the stamper, people got all worried that, hey, I don't see the raised seal, so I went out and bought one. Now, with the power of attorney, I mentioned that it's effective right away or only upon disability. It's effective right away. It's called the durable power of attorney. Stays in effect even if someone becomes disabled. If it's effective only upon disability, which we don't recommend, then that's called the springing power of attorney. It only springs into effect if someone becomes disabled. So our client Fred the carpenter, he's trying to decide on the power of attorney, and he goes, Kenny, explain to me in carpenter language, I don't understand this legal stuff on the power of attorney. I go, okay, you have your son as the agent, right? Well, if you sign effective right away, that means that he can steal everything you have and then go to Cuba and live like a king where it's won. If it's effective only upon disability, then he has to get a note from the doctor before he steals all your money. I go, having said that, do you trust your son? He goes, I trust my son a lot. Good, make it effective right away. But it's important to have, because I might have mentioned earlier, every other week we get a call, I need to get power of attorney over mom, dad, my brother, Uncle Joe. Okay. Can they sign their signature on a piece of paper? And can they talk to us, yes or no? If the answer is no, I goes, well, then we can't do something. Well, what can we do? I goes, well, because they can't sign, you have to go through this expensive, complicated procedure called the guardianship. It takes a couple of months, costs a couple of grand, and you don't want to have to do it. There were some of these Wells Fargo and other companies weren't honoring properly done New Jersey powers of attorney. So there was got to be done in our form, but it was passed at the time so. New Jersey legislature came down with a statute that covers the banks that do business in New Jersey, that says this is properly signed and notarized, you got to honor it. However, the document had the reference to the statute that was section 2 of PL 1991 C95 C46:2B-11, and that's why the circuit also says don't use free things online, because it doesn't have that reference. Have one done right. Now, a will, I mentioned, is good for really forever. There's no statute on how long a power of attorney is good for. So we typically recommend that someone sign a new one every 5 years. Why? Not because I'm making a whopping $75 or whatever. It's because that if it's up to date, then it's better. And sometimes you'll be talking to someone, and I'll think about, what about this, what about that? Our rule of thumb also is the executor and your agent. Can they drive to the bank? Can they walk up a flight of steps? Can they drive to a bank and do stuff? We're not anti-senior citizen, we're practical. It's kind of difficult in our county. Some people say, listen, I don't have anyone in the U.S. I go, well, they don't have to live in the U.S. They can be in whatever other country. But sometimes I say, can they read and write English? Because they're gonna act. So okay, I got 300 more seconds. The last document I'm talking about is the living will against Directive. That is the document where someone's in a coma, irreversible condition, and you're really giving instructions to the hospital. The doctor's saying, this is what I want, or usually this is what I don't want. And in our documents, the documents is really for your family, not for you if you're the sick one, because you can't. It's only if you can't talk. But it's kind of the end of life thing because of either like a terminal illness or a sudden accident. And so, typically, 95% of people say, listen, there's no hope of me. I can't talk. I'm brain dead. Or I don't want feeding tubes. I don't want fluids and nutrition. I don't want to have artificial machines and all this. I used to say, because me and Dan do these triathlons, if I can't run every day, I want to be put down like they do the racehorses. I want to run every day. I missed their running for 15 years. And then it was January 6th, and I had heel surgery the day before, and I'm on crutches with a big cement thing, and it snowed, because my original plan was to try to crutch around the block to keep the street going. And that wasn't in the cards. I go to my wife, hey, don't put me down yet. I still got a couple more years. That's it. So, but remember, the living will isn't for you, it's for your family. So your family does not have to be put through the trauma of where there's no document, the doctor saying, what should we do? Because I remember one time a doctor asking me, it wasn't a family member, I was the power of attorney because she didn't have family in her assets going to charities. The doctor goes, but should we remove life support today? Geez, doctor, I feel bad. I mean, I know what the right thing is for a 92-year-old lady that's not going to see the light again, but you hate to be the one who says, yeah, go ahead and do it. Let's see. So that's why we encourage people to do it. Let's see. You're also putting forth an agent 1 and agent 2 that they can talk to. And each other year we revise documents, though. We add a HIPAA authorization. It's kind of funny, though, who's going to be the agent. Some people don't have the same person as the executor to be their agent on their living will. When I was first married, and when you're first married, you're all lovey-dovey, and my wife and I redoing the documents, and my wife goes, I could never let them pull the plug on you. And then like 25 years later, she's like, okay, so if he gets dead, I get $850,000 tax-free. And I can quit my job and I never have to work again, right? Can't we put you down now? Let's pull the plug on you now. I don't have a firearm in my house, by the way. I'm afraid that one of those days my wife's gonna pull the plug on. Let's see. And I was a municipal prosecutor for 9 years. The other trouble with having a firearm was that people panic, and then the person takes it off. Like when I was in prison, I go, where's my weapon? He goes, I give you a weapon. Oh, I'm entitled to a weapon. He goes, if you have a weapon on you, they're going to take that off you and stick it where you don't want it. Oh, now I understand. So we also have a section for organ donation. So for the people listening out in the world, my name is KENNETH VERCAMMEN. My office is in Edison, New Jersey, not that far away. The office phone number between 10 and 3 is 732-572-0500. I only say that only because I repeat it. It's on the papers. But I say call between 10 and 3 because at 8:59, I don't want to be getting calls because we're still like getting in. And I was out of the country with my wife, and someone called me Sunday afternoon, and I goes, no, sorry, I can't help you today. Let's see. All right, so okay, Dan, you're up.